Number 23 TRD 802. Good morning. Mr. Colton, did you understand all of the rights and plea options I explained to everyone?
For the most part, if I'm not wrong, I am entitled to a crash report or an accident report, as you said.
Well, if you're not wrong, then you want to plead not guilty today, right?
Yes, sir.
Okay, so, and that can be obtained by you and or your attorney from the law director or the prosecutor's office.
I have asked, I've went to records and it is not available.
Okay, well, we can deal with that later.
Okay.
This is your initial appearance hearing. Did you have any questions about the rights and plea options I explained to you earlier?
No, sir.
Did you receive a copy of this traffic citation that was issued on November 4th, 2020?
Yes, sir.
Okay, you are charged with one count of stopping after, or failing to stop after an accident or leaving the scene of crash or accident. A violation of section 335.12A1 of the Conneaut City Ordinances. If you're convicted of this offense, it's first degree misdemeanor. If you're convicted of this offense, you face a maximum 6 months in jail and a maximum fine of $1,000. Do you understand that?
Yes, sir.
Also, if there is anyone who is damaged as a result of your actions and you're convicted of this offense, the court could order restitution, order you to pay restitution to that victim of up to $5,000. Do you understand that as a possible consequence? Finally, if you're convicted of this offense, you face a minimum license suspension of 6 months up to a maximum 3 years. So do you understand that as a possible consequence? And how do you wish to plead to this charge? The court will accept your not guilty plea. Are you asking the court to consider appointing an attorney to represent you?
No, sir.
Okay, will you be retaining an attorney?
No, sir. I'll be representing myself.
That's not a wise thing, Mr. Colton, to represent yourself. You're not an attorney. You don't know the legal processes. So I
do have that.
From the very first seconds, the tone is set. A new judge, a new courtroom, and a defendant who walks in convinced that self-representation is just a formality. There's an immediate contrast between the casual attitude of the defendant and the structured calm of the court. This opening reminds us that courtrooms are not debate clubs or internet forums. They run on procedure, timing, and clarity. The judge isn't hostile, but he's clearly not here to entertain commentary or shortcuts. This is the moment where expectations should reset, but instead, the defendant seems to double down on confidence rather than caution, which quietly foreshadows everything that follows.
read and write English for the record. I'll provide you a document. It's entitled Waiver of Counsel. Take a few minutes to read it. If you find it acceptable, you can sign and date at the bottom. Court finds the defendant has executed in open court the written waiver of counsel document. In this case, Mr. Holton has decided to represent himself, so he will be pro se. Okay, Mr. Colton, I do not have a written bond recommendation from the prosecutor or law director, as this was a citation issued by the police officer, so I have to ask you a few questions. Do you live, the ticket has you at West Main?
Yes,
What's the apartment number?
37.
37 in Conneaut. How long have you lived there? 4 years? See, Mr. Colton has no prior criminal history in this court. And his last traffic violation was back in 2008. Mr. Holton does not represent to be a flight risk. I will set bond in the amount of $5,000 personal recognizance. And I will set this case for a pretrial conference in the near future. We're being released on your own recognizance, Mr. Colton. You're going to go, when you leave the courtroom, you're going to go to the clerk's window. They're going to give you a date and time for your next hearing. That will be the only notice you receive from the court, so make sure you put it on your calendar If you fail to appear for that hearing, I'll revoke your bond and then I'll issue a bench warrant for your arrest, okay? You could also, the city of county, have $5,000 if you aren't here when you're supposed to be here. Do you understand?
Yes.
Do you have any?
Here, the judge carefully explains rights, plea options, and the nature of the charge. This is the court doing its job properly, making sure the defendant understands exactly what is happening and what is at stake. The defendant raises the issue of a report, already showing confusion between entitlement and procedure. The judge doesn't shut him down. Instead, he explains that this can be addressed later and keeps the hearing on track. This segment highlights how initial appearances are about orientation, not litigation. Courts give defendants space to ask questions, but only within the framework of process, not strategy or argument.
So if you're going to ask me, like you're not the first one who's going to ask me legal questions. I cannot answer your legal question, only procedure. So you have any procedural questions for me?
Yes, I do.
Go ahead.
I would like to know why I am not getting an accident report.
Mr. Colton, you're going to represent yourself. There are what we call rules of discovery. So I would advise you to talk to the prosecutor or law director's office, which is across the hall, and then they'll provide that to you.
Is there a reason you can't?
This is where we get into the situation where a non-lawyer isn't familiar with the procedures. The court doesn't provide discovery. Discovery is exchanged between the parties.
How come the records office will not give me a copy?
Talk to the law director's office.
This is where the weight of the charge becomes clear. The judge lays out potential consequences in plain language: possible jail time, financial penalties, restitution, and license suspension. Nothing is exaggerated. Nothing is hidden. The defendant acknowledges understanding, yet there's a sense that the seriousness hasn't fully landed. This part shows how courts prioritize informed consent. A plea entered without understanding is meaningless, so the judge methodically checks comprehension. It's a reminder that the system is designed to protect rights first, even when the person exercising those rights may not fully appreciate the risks.
Get back in here.
Sir, get back in court.
Sit down. What's your problem?
I believe I'm getting...
Now comes the pivotal decision: representation. The judge openly discourages self-representation, not by denying the right, but by explaining the danger. This is rare honesty from the bench, and it's done to protect the defendant, not belittle him. The analogy used drives the point home. Having a right doesn't mean exercising it is wise. Still, the defendant insists. The waiver of counsel is introduced, read, and signed in open court. This moment matters because once that document is signed, the responsibility shifts almost entirely onto the defendant's shoulders.
I found you not guilty. I've accepted the not guilty plea. Be quiet! Be quiet! Or I'll hold you in contempt of court. Now, why do you feel railroaded? Because you went to the police department and asked for a copy of the report. You went to the wrong office. And any attorney would know that. You go to the law director's office, which is prosecuting this case. And you don't get it from the court. Any attorney knows that. You might want to reconsider representing yourself, Mr. Colton.
No, sir.
Okay. Do you have any other noises you want to make before you leave this courtroom?
No, thank you.
Then get out of here without making a noise.
With counsel waived, the court moves into bond and logistics. The judge asks practical questions about residence, history, and flight risk. The outcome is actually favorable to the defendant: a personal recognizance bond and release. This part shows judicial discretion working in the defendant's favor. The court isn't punitive here. It's measured and fair. Clear instructions are given about the next hearing and the consequences of failing to appear. Everything is spelled out. There's no ambiguity, no trap, just straightforward expectations that must be followed.